Okay, so good afternoon, everyone. So we will now watch the pre-recorded videos provided by Attorney Soriano. Kindly turn on your cameras as well. Hello, madunggan na ninyo. Nagiwala, Jude.
Dili ba? Wala.
I-start na to again, guys. Ikaw.
Dili ka tong
Ikaw.
tulog.
Start na again. So, sorry. Wala dahil siya na. Madunggan na ninyo at like, inana.
Good afternoon. So we're done.
Okay, so good afternoon, everyone. Okay, sige, sige. I-cut lang na ako pag-edit. So, good afternoon, everyone. So, we will now watch the pre-recorded video provided by Attorney Soriano.
About the essential requisites or essential elements of a contract. And you have learned that in order for a contract to be valid, there must be the presence of three essential requisites, such as a valid object, you have a valid cause or consideration, and a valid consent. Now, a form of a contract is not essential to the validity of a contract because there are only three essential requisites of a contract: consent, object, cause, or consideration. However, in these three instances mentioned under or enumerated under item 1, number 1, unless there is a law that requires that a contract be in a certain form in order to be valid, then form in that particular contract is an essential requirement for the validity of that particular contract. As I said, the contract does not require a specific form. It could either be in writing or it could either be orally made or partly oral and partly in writing. But there are certain instances under number 1, A, B, and C. These are the instances wherein it requires that a contract be in a certain form so that, or it must be in writing in order for the contract to be either valid or to be enforceable. Letter A there states that when the law requires that a contract be in some form to be valid, if there is a law that requires that the contract be in a certain form in order for that contract to be valid, then form becomes there an essential requisite of that particular contract. But generally, contract need not be in a certain form. How about if the law requires that the contract be in some form in order for it to be enforceable? Then it has to be in writing in order for it to be enforceable. Remember those instances that falls under statute of fraud, which requires that this following agreement needs to be in writing in order to be enforceable. Then for the contract to be enforceable, no, it needs to be in writing. But generally, contract need not be in a certain form. It could either be oral or in writing, unless there is a law that requires that in order for that contract to be valid, it has to be in a specific form. Meaning, the law there specifically states that the contract should be in writing in order to be valid. Then the non-compliance of that specific form would render the contract invalid. Or under statute of frauds, when the law requires that the contract be in some form or be in writing in order to be enforceable, then it has to be in writing in order for the court to enforce whatever it is in the contract. The third instance here states that when the law requires that a contract be in some form for the convenience of the parties or for the purpose of affecting third person. So I want you to go over De Leon's example in these enumerated instances. Now, another rule under form is that form is not an essential requisite of a contract unless there is a law that requires that it should be in writing in order to be valid, such as donation of real property, land to another must be in writing in order to be valid. Now, form for validity of contract. These are the rare cases when the law requires that the contract be in a certain form for the validity of the contract, such as donation of real property. When you donate a real property, it must be in a public instrument. The law says it must be in a public instrument. So it presupposes, because it must be notarized, then the agreement, the donation, the deed of donation, or the contract of donation there must be in writing. Kasi in-notaryo mo eh. So kailangan din in writing. So the requirement of the law there, it must be in a public instrument. So it presupposes that the agreement must be in writing so that it can be notarized. Number 2, donation of personal property, the value of which exceeds 500,000. It should be more than 500, more than 5,000. The donation and acceptance must be in writing. The first one refers to real property. The second one is the donation of personal property. But as far as the donation of real property is concerned, there is no amount indicated. There is no threshold. Regardless of amount, as long as you donate a real property such as land, it must be in writing and it must be notarized. Third, sale of land through an agent. The authority of the agent must be in writing. It's not the sale of land. It's not only the sale of land, no, but it also the SPA, the special power of attorney authorizing an agent to sell or mortgage the land, must be in writing. Otherwise, the sale is void. If the SPA there is not in writing, it carries with it the nullity of the sale, because the agent there is acting in a representative capacity. The agent is acting in behalf of the principal. So if the agent there is not authorized in writing for the sale of land, then the sale there, it becomes void or invalid. Contract of anti-crisis, which you will learn, I don't know if the school will still be offering law on sales for this in the second semester. But anti-crisis, you have there a different kind of contract. The amount of the principal, land, and of the interest must be specified in writing in order to be valid. Stipulation to pay interest. If there is a loan, a contract of loan, and if there is no stipulation to pay an interest, then the interest there must be expressly stated in writing, otherwise no interest is due. Contract of partnership, if one of the partners will contribute immovables, it must also be in a public instrument to which shall be attached a signed inventory of the immovable property contributed. Kasi as partners in a partnership, some of the partners need not invest just cash, no? Or it could be either also be in a form of a property. So if the property contributed by one of the partners are immovable property such as land, then it must be made the contribution, the whatever deed it is, it would be deed, it can be deed of assignment, deed of sale, deed of donation, it must be in a public instrument. Transfer or sale of large cattle, if magbaligya ka ng large cattle, it must be registered. So it must be in a public instrument and a certificate of transfer secured. Negotiable instruments such as promissory note or such a bill of exchange, no, such as checks, they must be in writing in order that you can further negotiate the negotiable instrument, further endorse it to another person. Now, the instances that I have enumerated affects the validity of the contract. In these 8 instances, no, though they are not exclusive, meaning there are some other instances which affects the validity of the contract if it does not conform to a specific form. Ang kanina man sa item B refers to the enforceability of a contract. The contract in the agreement that falls under item B are valid contracts. It's just that in order for the contract to be enforceable, there are some instances that it requires a specific form of a contract. Kinahanglan na in writing dapat. That's what the law is trying to tell us. Now, in the cases of contracts covered by the statute of frauds, the law requires that they be in writing, subscribed by the party charged or by his agent. If the contract is not in writing, the contract is valid, assuming all the elements are present, such as object, cause or consideration, and consent. No, but upon the objection of a party, it cannot be proved and therefore it cannot be enforced unless it is ratified, because unenforceable contracts are valid contracts. It's just that the court cannot enforce the contract against the other party and it is subject to ratification. Now, let's go to reformation of instruments. What is the meaning of reformation? Reformation is that remedy, no modo kunoy remedy, by means of which a written instrument is amended or changed or rectified utruhon so as to express or conform to the real agreement or intention of the parties when by reason of mistake, fraud, inequitable conduct, or accident, the instrument fails to express such agreement or intention. What are the requisites of reformation in order for you to avail of such remedy? In case the parties, kung kamo nagsabot, but your intention was not expressly stated in the contract, or your intention is different from that what was written in the contract, you need not cancel the contract. You only need to reform it to conform to the real intention of the parties. What are the requisites? Number 1, there is a meeting of the minds of the parties to the contract, meaning the parties have agreed. There is no dispute between the two. Between what was agreed upon by the parties. Both parties have agreed the same thing. There's meeting of the minds. But the written instrument does not express the true agreement or intention of the parties. The defect is not on the intention or the consent of the parties, but it was the intention of the parties did not reflect in the contract. Number 3, The failure to express the true intention was by reason of mistake, fraud, inequitable conduct, or accident. Those are the grounds busa wala na express sa contract no ang ilang intention ng parties. The facts upon which relief by way of reformation of the instrument is sought are put in issue by the pleadings. And there is a clear and convincing evidence, which is more than mere preponderance of evidence, of that there is mistake, fraud, it was due to mistake, fraud, inequitable conduct, or accident, and both parties must have executed in writing that it does not reflect their actual agreement. Reformation is not available when there is where no writing exists, or a writing exists but the parties do not intend it to be the to express their final agreement, or no attempt is made to show any vice consent therein. Reformation is not available kung wala nag-agree ang parties, dili mao ang giagrihan. Okay? Or walay nag-exist nga in written instrument, or naamang gani nag-exist na written instrument but the parties do not intend it to express their final agreement, dili mao. But if the parties, their intention, pareho silang intention, but wala lang na-reflect sa contract or instrument, then no need to cancel the agreement. You only need to reform. Utruhon lang no, ang instrument. Interpretation, on the other hand, is the determination of the meaning of the terms or words used by the parties in their contract. Determining the intent of the parties is usually what courts say it is when they interpret a contract language in a particular case. As I said, for those who weren't able to attend my previous lecture, before a contract is signed by the parties, both parties must ensure no, that the terms there are very clear. The terms used by the parties is very clear, and both parties must have agreed to the terms. It's very clear, and there is no room for confusion or no room for interpretation. Basta klaro. Interpretation is the act of making intelligible that was not before understood, or if ambiguous or not obvious. It is a method by which the meaning of language is ascertained. On the other hand, reformation is that remedy in equity by means of which a written instrument is made or construed so as to express or conform to the real intention of the parties. Because you don't want to be bound by the contract that you don't understand the terms under that contract. That's the reason why there's a lot of cases now for breach of contract or cancellation of contract, annulment of contract, because of the terms that are ambiguous, or the terms that might connote different or several meanings, no? that other parties may not want to be bound, no, by those terms. It is a cardinal rule in the interpretation of contracts that the intention of the contracting parties should always prevail, because their will has the force of law between them. That's why even if the intention of the parties, the will of the parties versus the terms of the contract, it is the intention of the parties that will prevail, as long as both parties have agreed, no, that the terms and in that contract did not reflect their intention, then they only need to reform. Kung nahimo na ang contract, no, i-reform. But kung wala pa nahimo ang contract, wala pa na kamulo paghimo sa contract, no, and wala pa nagpirma ang parties, then both parties need to go through all the terms and conditions of the contract and try to brainstorm, no, and try to interpret the terms in that contract. Like for example, if you're selling something, you're selling all of all of your furniture in the house. So mingon kag furniture, of course, it does not cover appliances. So if the other party would say, eh, abi na kog appliances, no, appliances like such as electric fan is not considered furniture. So kumbaga pa, you have to make sure that the terms there is you intended it to be the terms, no, in that contract, and there is no room for further interpretation. So as I said, reformation is a remedy when the contract is already done, when the contract is already executed, but it did not conform to the real intention of the parties. So you need only to change it. Reform lang. No need to cancel. Okay, that's reformation. Interpretation, on the other hand, could be done before signing. You interpret the contract, you try to go over the terms and conditions of the contract and try to uh, see the implication, no? Try to unsay effect ani sa ako, unsay effect ani sa Picas party, no, the implication of the terms and conditions under the contract. You need to know that. And interpretation can also be done when there is an issue in that contract. No, you go to court. The court, no, may interpret the contract for the parties. Such as if a party, contracting party there will file for an annulment of a contract, then the court, no, will interpret that contract. Or if there is an issue as to the payment of interest, or as to the remedy of the party, as to the rights and the rights of the debtor or creditor, then the court may interpret the contract for the parties. Now, let's go to the defective contracts. I know some of you have already, you have submitted your reports, so you are quite familiar of your reports, and you have also, I gave you time to go over the videos submitted by the other groups. Then probably you already have a good idea of these defective contracts. Why is it important to know what are the defective contracts? Because in order for you to prevent creating one, in order for you to prevent signing one, no, and because what's the use of executing a contract that you know that it is defective? Contracts supposedly are meant to regulate, no, the responsibilities or the obligations of the parties. It is the proof, the tangible proof of the agreement of the parties. Now let us go to the different kinds of defective contracts. You have rescissible contracts, voidable contracts, unenforceable contracts, void or inexistent contracts. Rescissible contracts, they are the least infirm or defective. These are the least. They are valid because all the essential requisites of a contract exist. But by reason of injury or damage, you call it an economic damage or lesion to one of the parties or to third persons such as creditors, the contract may be rescinded or canceled. Thus, the defect is external. Until such contracts are rescinded in an appropriate proceedings, they remain valid and binding upon the parties thereto. So rescissible contracts, as I said, are valid contracts until rescinded in court, no, until they're canceled in court. Their defect is external, no? The rescissible contract, the defect niya is external. And how about voidable contracts? They're also valid. Voidable contracts are valid contracts until annulled. You go to court and have it annulled. You call it annulment of contract. Unless there has been a ratification. If the other party, the aggrieved party, the incapacitated person, or the person whose consent was vitiated by reason of the causes enumerated under the law, no, they are allowed to ratify it. Once the Once the incapacitated person or those person whose consent was vitiated, once they ratify the contract there becomes valid and binding from the moment it was executed. It cleanses the defect of the contract. Ratification cleanses the defect of the contract. It cures the defect. So in avoidable contract, the defect is also caused by vice of consent, such as fraud, mistake, undue influence, violence, and other causes. Unenforceable contracts, on the other hand, they cannot be sued upon or enforced unless they are ratified. As regards to the degree of defectiveness, voidable contracts are further away from absolute nullity than unenforceable contracts. In other words, an unenforceable contract occupies an intermediate ground between a voidable and a void contract. The fourth one is the uh, very defective, because it cannot produce any right, that contract, because it is considered void from the very beginning. These are void or inexistent contract, absolutely null and void. They have no legal effect at all and cannot be ratified. Void contracts cannot be ratified. Now let us go over examples of rescissible contracts under law and obligations and contracts. So rescissible contracts are those validly agreed upon because all of the essential elements exist and therefore legally effective, but in the case established by law, the remedy of rescission is granted in the interest of equity because the other one there suffers economic damage or lesion. Requisites of rescission, first is that the contract must be validly agreed upon. Very important that the contract must first be valid. Because if it is a void contract, then it cannot be a rescissible contract. So there must be the presence of the three essential requisites of a contract: consent, what else? Object, cause, or consideration. But by reason of the economic damage or lesion, then in the interest of equity, the contracts are considered rescissible. And those that are aggrieved party, aggrieved contracting party, such as the minor or the absentee or the creditor, may go to the court and have the contract rescinded or canceled because of that economic damage or lesion. Second, there must be lesion or pecuniary prejudice or damage to one of the parties or to a third person, even to a third person who is a remote person in the contract, not a privy to a contract, not a party to a contract. If that third person benefits from that contract, such as a beneficiary. Number three, the rescission must be based upon a case specially provided by law. There must be no other legal remedy to obtain reparation for damage, because rescission is a subsidiary remedy. Now, if there is no other legal remedy, then you can rescind the contract, because rescission is a remedy frowned upon. Kasi if in law and contracts, the first thing to do, ang gabuhaton gyud pirmi, is to enforce whatever it is in the contract. Last resort would be cancellation. So if there is no other legal remedy to obtain reparation for the damage, then rescinding a contract can be the proper remedy. Number five, the party asking for rescission must be able to return what he is obliged to restore by reason of the contract. Because the effect of rescissible contract is restitution. Ibalik ang napalit, or ibalik, mutual restitution gani. It is good as if ibutang nimo ang parties atong wala pa sila nag-execute sa contract. Kung ang contract palit manggali, baligya mangani, or contract of sale, then the seller there can get the property back and the buyer can get the money paid. Money has paid to the seller. Number 6, the object of the contract must not legally be in the possession of third person who did not act in bad faith. Because third person who is in good faith in buying, no, for example, na ay third person nga nagpalit nga in good faith, it says here the object of the contract must not legally be in the possession of third person who did not act in bad faith, because nga the remedy of this contract is restitution. The effect of the contract is restitution, ibalik tong property. So it cannot be done when you cancel the contract, and if that the object sought to be returned is already in possession of a third person who is in good faith, legally in possession of the object, then rescission will no longer be possible. The last one is the period for filing the action for rescission must not have prescribed. 7 is more of a procedural matter, meaning there is a prescription. It's not the prescription that you're thinking of. No, prescription, doctor's prescription. Now, prescription here means that the law provides a certain period for a person to cancel that contract. If that period lapse, mag-expire ng period, you lose your right to have the contract canceled. So, provided that the period for prescription has not yet expired, that you can still have the right to file an action or the right to cancel the contract in court. So the following are rescissible contracts. Number 1, those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. As I said, ang example, ang guardian nag-atiman sa isa ka minor nga orphan na, and then ay property that the parents left for that kid, and the value of the property, like for example, let's say 1 million, and then the guardian sold it only for 500,000. Ang gansi is half, 500,000. That's the economic damage that the minor or the ward, kasi ang ward could either be minor, insane, kana mga timanunon, no? Mga incompetent. They cannot take care of themselves.
Wait lang guys ha. Akong i-play ang second na video.
Wala kami nasaksapan na video.
Tell me if madunggan ninyo ha.
So the following are
Madunggan ra. Okay, let's start.
rescissible contracts. First, those which are entered into by guardians whenever the wards whom they represent suffer lesion or economic damage by more than 1/4 of the value of the things which are the object thereof. Second, those agreed upon in representation of absentees if the absentees there suffer the lesion stated in the preceding number. Number 3, those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. Those which refers to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. Fifth, all other contracts specially declared by law to be subject to rescission. Number 1 is, I'll give you an example. No? Ward there, whenever the term ward there refers to a person who are incompetent or they cannot protect or they cannot take care of themselves, no, such as minor, insane, katong kinanglan at timanunon kay dili nila kaya buhion ilang kaugalingon. So here, if a guardian, this Well, I'll give you an example. No? A guardian is administering a property of a minor. Then the value of the property is 1 million. And then the guardian sold the property of that minor. Minor ha, orphan, without, orphan, wala na yung mamagpapa. Then the guardian sold the property worth 1 million to 500,000. So in that particular example, the economic damage or anggansi na suffer sa minor is more than 1/4 kasi 1/2 gani sa value ng property. That minor can go to court, no, and have the contract canceled. When he reaches the age of legal age, he can go to court and have it canceled. Second is those agreed upon in representation of absentees. Kung naay tao whose whereabouts is unknown, wala na bawaan kung asa, nawala na pila na katuig. And then there was somebody administering the property for him. And kaning administrator niya sold the property again for more than 1/4 of the value. Ang lesion is more, ang gansi is more than 1/4 of the value of the thing, which are the object thereof. Then the absentee, the appearing absentee, kung if that person will appear, no, can have that contract entered into by his administrator and the other person canceled in court because that absentee suffered lesion or economic damages more than 1/4 of the value of the property. Number 3, creditors who is not a party to the contract, is not a party to a contract, can have them a certain remedy. The creditor can go to court and have the contract canceled if the purpose why why one of the parties there nautangan aning creditor ning contract in order to defraud that creditor. Then that creditor can have the contract canceled. Fourth, if naay ang yuta nga gibaligya sa one of yuta gibaligya sa defendant, no, and without the knowledge and approval of the litigants or of the competent judicial authority, no, the party there may go to court and have it canceled. And all other contracts specially declared by law to be subject to rescission. Kasi there are some contracts, though not among those enumerated in Article 1381, which the law allows, no, that it can be canceled or rescinded in court. Article 1383 is just a reiteration of what I have discussed earlier, that the action for rescission is merely subsidiary. It is a subsidiary remedy. Meaning if there is no other legal remedy available sa party, then he can pursue, no, an action for cancellation or action for rescission. Because as I said, cancellation is frowned upon. Ang kuan gyud is to enforce, no, the whatever it is in the contract. Cancellation is the last resort, the last remedy available, no, sa party. Now, what are the effects of rescission? You have obligation of mutual restitution. And second is abrogation of contract. Ang effect ng rescission, if the party would avail the remedy of rescission, one of the effect is mutual restitution. Ibalik ang butang. If it is a contract of sale and the creditor there went to the court and canceled it and na-cancel ang contract, the parties, if it is a contract of sale, the seller can get back the property and the buyer can also get back the amount paid to the seller. And second, it is an abrogation of a contract. Abrogation means good as if walay contract na execute ng parties. That is the effect. If the contract is canceled, then it is good as if there was no contract entered into by the parties. The third effective contract is voidable contract. Voidable or annullable contracts are those which possess all the essential requisites of a valid contract. Just like rescissible, voidable contract is also a valid contract. But one of the parties is legally incapable of giving consent, or consent is vitiated by mistake, violence, intimidation, or undue influence or fraud. There are two types. One, those where one of the parties is incapable of giving consent to a contract. Second, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Now, these are voidable, the main category of voidable contracts. Now, let's go to item 1. Those where one of the parties is incapable of giving consent to a contract, such as minor, insane, deaf mute, person under hypnotic spell, drunkenness, dementia, Alzheimer. Kanang dili siya he is not fully, kanang, it does not, ang test kasi ani is if he's deprived of his will, parang he is deprived of his intelligence in making sure that is deprived of his intelligence in ascertaining no, the terms and conditions of the contract, and what is the implication if that person, incapacitated person, enters into that contract, and what is the sanction for non-compliance. These person are deprived of that capacity to understand whatever it is in that contract. Number 2 is those where the consent is vitiated by mistake, violence, intimidation, or undue influence or fraud. Those are voidable contracts. Now let's go to unenforceable contracts. Unenforceable contracts, just like rescissible and voidable, these are valid contracts. But unenforceable contracts, they cannot be enforced in court or sued upon by reason of defects provided by law until and unless they are ratified according to law. Voidable contracts can be ratified. No, rescissible contracts can be, I think, can also be ratified. And unenforceable contracts can be ratified. And as you have learned, ratification cleanses or cures the defect of the contract. The defective contract, the moment it is ratified, it becomes valid and binding contract. Not the moment it was ratified, but the moment the contract was executed. Article 1403, the following enumerates the unenforceable contract. Number 1, those entered into in the name of another person by one who has been given no authority or legal representation or who has acted beyond his power. Ang number 1 creates a situation wherein the person transacting in behalf of another person has no authority or naamagani authority but acted beyond his powers. Then that contract is considered unenforceable. Number 2, those that do not comply with the statute of frauds as set forth in this number. In the following cases, an agreement hereafter made shall be unenforceable by action unless the same or some note or memorandum thereof be in writing and subscribed by the party charged or by his agent. Evidence, therefore, of the agreement cannot be received without the writing or a secondary evidence of its contents. Number 1, an agreement that by its terms is not to be performed within 1 year from the making thereof. A, B, C, D, and E, and F requires that all of these agreement must be in writing. Number 1, an agreement that by its terms is not to be performed within 1 year from the making thereof. No, kinahanglan in writing. A special promise to answer for the debt, default, or miscarriage of another, kinahanglan in writing in order to be enforceable. An agreement made in consideration of marriage other than a mutual promise to marry, kinahanglan in writing in order to be enforceable. An agreement for the sale of goods, chattels, or things in action at a price not less than 500 pesos, unless the buyer accept and receive part of such good and chattels, or the evidence of some of them of such things in action, or pay at the time some part of the purchase money. But when a sale is made by auction, an entry is made by the auctioneer in a sales book at the time of the sale of the amount and a kind of property sold, terms of sale, price, names of the purchasers, and person on whose account the sale is made. It is a sufficient memorandum. E, an agreement for the leasing for a longer period than 1 year. Kung magrenta ka na more than 1 year, or magbaligya ka real property, or maskin interest lang anang real property, it must be in writing in order to be enforceable. The F, a representation as to the credit of a third person. And the last instance, the third main category, are those where both parties are incapable of giving consent to a contract. So, as I said, statute of frauds, last meeting we had, statute of frauds will only apply to executory contracts. It does not apply when one of the parties has already performed his or her obligations in the contract, because it would create injustice on the performing party. So 1, 2, 3. 1, kung ang person who's acting in behalf of a person has no authority, he's not authorized to represent that principal, or if he is authorized, has acted beyond his powers. Second, if it does not comply with statute of frauds wherein it requires that certain instances must be in order to be enforceable. And third, those where both parties are incapable of giving consent to a contract, then it is an unenforceable contract. As far as the third main category of an unenforceable contracts, kung duha ka buang nagsulod, no, nagpirminamaha og kontrata, nagsulod sa kontrata, the contract is not voidable kasi duha na kabuok. If duha na kabuok incapable of giving consent to a contract enters into a contract, then the contract is an unenforceable contract. Now, let's go to the most defective contract. Now, these are void contracts or invalid contracts. Void contracts are those which, because of certain defects, generally produce no effect at all. They are considered as inexistent from its inception or from the very beginning. The expression void contract is therefore a contradiction in terms. However, the expression is often loosely used to refer to an agreement tainted with illegality. So void contracts, these contracts cannot be ratified. Neither can the right to set up the defense of illegality be waived. It is not subject to waiver because these are invalid contracts. It produces no rights. It produces no legal effect. It does not bind the parties. The party, you cannot compel the other parties. It does not create obligatory force. There is no legal tie created in the obligations, in their respective obligations. Now, Article 1409 enumerates contracts that are considered inexistent and void from the beginning. Number 1, those whose cause, object, or purpose is contrary to law, morals, good custom, public order, or public policy. If it is illegal cause, illegal object, illegal purpose, then it is considered void, a void contract. Those which are absolutely simulated or fictitious contract are also considered void contracts because, like for example, if the parties created, no, nagbuot sila, inaon nang good nato, no, nagpalit ta og at nagbaligya ko para ingnon lang nga nagbaligya, but when in fact there was really no sale happened, or the parties have not really entered into that sale, then that contract is simulated or fictitious. Why is it considered void? Because the parties are not have no intention to be bound by the contract, no, na ilang gi-create. Number 3, those whose cause or object did not exist at the time of the transaction. Because we have learned in this course that in order for a contract to be valid, 3 essential requisites must be present. Cause or consideration, object, and consent. Absence of one, some, or all of these essential requisites would render the contract inexistent or void or invalid. So number three there is in line with that principle. Those whose cause or object did not exist at the time of the transaction. Walay object or cause. Number four naman, those whose object is outside the commerce of man. So if the object is not subject to a commercial transaction, no, such as selling of government property, no, because public property is not subject, it is not subject to a commercial transaction. You cannot sell that property because that property belongs to the government or belongs to the state. Number five, those which contemplate an impossible service. Like for example, if you will ask somebody, I will pay you, you hire somebody, you execute a contract of employment, and then you ask one of the obligation of the obligor is to perform an impossible service, such as carrying, I want you to carry the Xavier Chapel. No? That is an impossible, that is a void contract because of impossible service. It contemplates no an impossible service. Number six, those were the intention of the parties relative to the principal object of the contract cannot be ascertained. If, remember, the one of the requisites in order for the object to be valid as a requirements for validity of a contract, that it must be determined, it can be ascertained, it is certain, no, and determinate. So if the object there cannot be ascertained, then the contract there is void. And number seven, those expressly prohibited or declared void by law. An example of this is if a foreigner, foreign national, a national of a foreign country cannot, no, they are not allowed to purchase property in the Philippines because it is the policy of the state that the Philippine land should remain, no, uh, uh, remain or should be for the Filipinos only. And another example of number seven is if you are going to sell you are nag-grant ang state o patent. The state, the government gave you a piece of land under homestead patent or under patent. You're not allowed under the law to sell it, no, within 5 years from the grant. So if you're going to sell that, the contract you have entered into with that person is void, and the government can even have it reverted back, no, to the government. Summary of defective contracts: rescissible, voidable, and unenforceable. These are valid. They are valid contracts but suffers from a defect. Can be ratified. Once ratified, the contract becomes valid and binding. Void contracts, invalid contracts, cannot be ratified, produces no right, produces no legal effect, has no obligatory force. Now, natural obligations, now for purposes of just a summary, Article 1423 states that obligations are civil or natural. Civil obligation give right of action to compel their performance. Natural obligation not being based on a positive law, but an equity and a natural law, do not grant a right of action to enforce their performance, but after voluntary fulfillment by the obligor, they authorize the retention of what has been delivered or rendered by reason thereof. Some natural obligations are set forth in the following articles. Like for example, um, you nangutang ka, and there is a period within which your creditor can collect, no, pwede ato sa korte and i-collect niya ang imong utang. So if that period will lapse, nag-prescribe na nga period, ang katong creditor can no longer run after you. But kung nibayad ka voluntarily, you cannot go to to your creditor and ask for the payment back, because it is a natural obligation. Kay nangutang ko ka sa una, so it is your natural obligation to pay. You cannot ask for uh, if you voluntarily paid for it, maskin you are no longer parang obliged under the law to pay for it, but still you voluntarily pay for it. No, that's natural obligation. Kasi nga nangutang ka, and you are obliged also to pay maskin pag ni-prescribe na ang time to pay. Civil obligation and natural obligation distinguished. Ang civil obligation, those arising from a contract, that's civil obligation. Even those arising from crime, because criminal liability carries with it civil liability also. Also quasi-delict, no, because they're of damage that was caused by reason of negligence. Civil obligation may arise also from quasi-delict. Now, Article 1423 gives the distinction between civil obligation and natural obligation. Civil obligation arises from law, contracts, quasi-contract, delicts, and quasi-delicts, while natural obligation are based not on a positive law, but on equity and natural law. Whatever is just, whatever is fair, no, that's a natural obligation. Civil obligation give a right of action in courts of justice to compel their fulfillment or performance, while natural obligation do not grant such right of action to enforce their performance. So I think that's it for the whole course. So you have learned about the form, the reformation of contracts, interpretation of contracts, defective contracts, natural obligation. The discussion is a summary of all the topics that fall under this scope. Now, I want you to go watch the videos that your classmate has made, so that you can have a good understanding, no, of some principles that falls under these topics. So I will post this pre-recorded lecture as well as a forum that you can ask. You can ask me if you have are having a hard time understanding certain topics. Then I would be glad to explain it in the forum section. So thank you and have a good night.
Okay, so keep posted lang sa G for activities and announcements. Thank you. I'll stop now the recording.